Global happenings today. We communicate. We analyze global news. Stay tuned.
Hello beautiful people, welcome back to our channel. Right now as we speak, the CJN Justice Ikekere have waded into this matter, and this time around is demanding for a probe. But while the probe is about to kickstart, Eze have decided to describe exactly the situation. In fact, we just hope that eventually the judiciary will get its act together. But while they're all looking at that to happen, hear what Eze got to say. But before we go to the newspaper, please subscribe to our channel. A former National Publicity Secretary of the now defunct New People's Democratic Party, npdp, Eze, has advised the faction of the Rivers State House of Assembly led by Martin Amaewhule to bury their plot of impeaching Governor Sonalaye for Bara. Now, however, Eze pointed out that their defection to the All Progressive Congress (APC) has undermined their authority to engage in any legitimate legislative action. The APC leader highlighted that one instance of ProWike's faction opposition to the governor is reflected in a recent Court of Appeal ruling which mandated for Bara to resubmit the 2024 appropriation bill to the Martin Amaewhule-led Assembly. Eze explained that the appeal stemmed from a federal high court ruling that followed Fubara's withdrawal of all legal defenses in response to the suit filed by Amaewhule, a move directed by the President Tinubu after discussion with the conflicting parties involved in the political crisis in Rivers State. Now, the APC leader remarked that the ruling of the court, which the appellant court affirmed, represented a consequence of Wike's audacious defiance of President Tinubu's directive. Now, Eze further urged Wike and his associate to embrace the straightforward meaning conveyed by the Court of Appeal's decision to appeal number CA/ABJ/133/CS/2023 when interpreting the judgment. In a statement released in response to the various interpretations that emerged from the pro-Wike faction, who are making renewed attempts to perpetuate instability in the state, Eze emphasized that the ruling did not address the status of the seat held by the former lawmakers who had defected and voluntarily relinquished their position upon leaving the PDP, the party under which they were elected. Now, these seats were declared vacant on December 13, 2023 by the then Speaker of the Assembly, Right Honorable Edisinehi. He said Section 109, subsection IG of the 1999 Constitution of Nigeria is automatic and needs no judicial interpretation to take effect, and called on the former lawmakers to awake from the euphoria of the false narrative adopted and sold to them by their team of judgment interpreters, whose exciting but vague interpretations cannot help their situation. Given the Section 109 sub 1G takes automatic effect upon the defection of a member of a state house of assembly, one would have loved to see the Court of Appeal ordered a stay of proceedings on the matter to allow the determination of the question of whether or not the 27 former lawmakers are still members of the Rivers State House of Assembly. Judicial officers, especially judges, must be wary of being involved into a situation in which they find themselves becoming partisan agents of wrongdoers in the pursuit of very selfish and anti-people vendetta. Although the Court of Appeal verdict does not restore the former lawmakers to their lost seat, it has been exposed to ridicule, particularly by the Wike group, who are desperate to hold on to anything from the court to assert themselves. Such a situation, as I said, could cause chaos, and the court would have considered the fragility or frugality of the political atmosphere in the state to be circumspect in their handling sensitive situations such as this. Martin Amaewhule and his co-travelers are now hinging on the judgment of the appeal court, wrongly interpreted to them to assume that they have returned from their self-inflicted political relegation, so much so that they could muster courage to go to the extent of purportedly sitting to conduct legislative business when they have no such powers. Eze reminded those who, according to him, seem lost in the euphoria of the ridiculous interpretation of the Court of Appeal judgment that the question of whether or not the 27 former lawmakers have not lost their seat by virtue of their defection is still pending before the court, and until the question is determined in their favor, they remain former members of the Rivers State House of Assembly and therefore lack the legitimacy to carry on any legislative function for the state. He called on Amaewhule and company to bury the thought of attempting to impeach governor, as that will backfire on them. And he counseled them that to be circumspect and mindful of the kind of orders they take from Wike, stressing that FCT minister allegedly does not mean well for the state, and the people should be careful not to make themselves willing tools in his hands to destroy the state. These are the words of Eze. But the question now is, with the newest version coming in, because he still insists that the constitution is self-explanatory, and what they did by defecting is also self-executory. But then again, the way the judges are literally avoiding that particular section, instead moving on to the other one that does not concern. It's as if they're just, like he rightly said, being partisan in a situation where they ought to be very neutral. My colleague is in the house. What's your take on all of this?
Right. Well, the issue is very transparent, but just that, unfortunately, being that the law in itself is what it is based on the interpretation that is given to it, that's where there's a lot of fears right now. And currently, we've heard about the fact that the National Judicial Council will be having a chit-chat with those who were involved, that's the judges, and we do not know what will play out there. But don't forget, this is a regulatory body, the body that is in charge of discipline and all of that. So if they begin to dish out disciplinary moves against the state judges, it might end up, affecting the whole court cases, and before you know, everything will go the path of the 27 lawmakers. It's really unfortunate, I must say, really unfortunate that Nigeria is a country where this kind of things can be, played down on, where people came out, they went even and they posed an affidavit telling the whole world that they have become, they read it in the hollow chamber. This is not something that was forced into their mouth. Even during the 5 million man march, they stood out again and said that they followed due process to decam. It was in their mouth. Their letters of decamment, it's also the minutes of that day. We saw him in the video reading it. But then you still see some games going on in the court, the interpretation, left, right, center, and they believe that nobody should be sane enough to interpret what those guys did there. That is the way it's quite troubling. And I'm just wondering what the future is. Now, as we are speaking right now, if anything happened that a camera in a house caught some persons walk into that house and steal something from that house, the court will accept that is an evidence against them, and they will use it squarely, even when that thing was not found in their hands. Why is it that we have seen videos upon videos of these guys decamping? The minute of that, they clearly spell it out. They have mentioned it not once, not twice. We've seen them, showing the flag and singing the anthem of APC. But yet, we are still playing games, dribbling it up and down. Now, unfortunately, I've always been saying, someone talked about the issue of the jurisprudence, the philosophy of law, that they are waiting for the Supreme Court to add more to the jurisprudence. And I'm telling you that whatever that will be added to the jurisprudence, the judges or whoever that is behind or who's going to be dealing with this case should sit back and watch how the judiciary is going to nosedive in the next 10 years. That he himself, or let me say the next 10 years, next 20 years, he himself will be shocked on how the antecedents of the cases they have handled, the precedents of the cases that they have handled will be affecting other cases. Because imagine this is happening now, and another person decides to decamp now and begin to, clinch on some of the Supreme Court judgments that have been given on the case of decampment. What will you now say? It's mind-boggling. It's quite troubling, I must say. But I'm hopeful that they will retrace their step and do what is right, no matter how you have to go to school to be a judge and all of that. These things are well spelled out. A thief is a thief, whether in the court or anywhere. A thief is a thief. You understand? If someone does what is wrong, everybody, wherever you are, you know what he has done. It is wrong. And just like the man has said that it is self-explanatory. It is not something that the judiciary needs to interpret to Nigeria. If you decamp, this is the provision of the Constitution that you lose your seat. simple, then why are we playing games over it? Why is it something that we are pounding on this and that? And it's really troubling that we are in this kind of situation. I'm hopeful that the judges will do the right thing as at this time.
That's a good wrap.